Hi, Ma'am Ria. Good morning.
Hello, good morning, Ella.
Um, I'm here to ask you something about IP because I know you are a patent agent. So, can you give us a clear discussion about intellectual property?
Okay, first and foremost, I'd like to express what's important about intellectual property is that it is a property or an asset that is a product of the human mind. So, intellectual property as a property is very much similar to owning any type of physical property. Example, you own a lot, you own a car, you own jewelries. No? They are called physical property in tangible form. But the intangible form of property is called intellectual property. The human mind is capable of creating, inventing, innovating, but this intellectual property must, in order to be intellectual property, the ideas must be expressed. So example, if we're talking of a copyright, you have an idea about a song.
Yes.
So to make it an IP, you have to express it. You have to write it. Whatever is in your mind, you have to write. You have to draw. You have to make the prototype, etc. So expressing the human mind in whatever form is an intellectual property. After that, we have the so-called intellectual property rights. These rights will now be part of, we call the IP Code of the Philippines, the Republic Act 8293, wherein it extensively explains the patent law, we have the trademark and service mark law, the copyright law. Doon we can find what are our rights as the one who created the intellectual property. So bawat, no, there are actually 7 types of intellectual property.
Ah, I see.
Okay? So we have the copyright as an automatic intellectual property, meaning it is automatically yours the moment you created it.
That's copyright.
Yes. It is optional actually to apply to the intellectual property office or the um, the National Library for a copyright copy, no? Kasi nga automatic from the time that you've created. Copyright is also known as artistic and literary innovations.
I see.
And what's good about copyright, excitingly, is that the right or the protection is until 50 years after the death.
Mm.
Okay. You enjoy 2 rights. You enjoy the economic right and moral rights within that span of the protection. When we say kasi rights, no? How are you protected by the law having that kind of intellectual property? Now we have the patents and utility model. Patents and utility model actually is called the technical innovations.
Okay.
Normally, a solution to a technical problem. It could be a product or a process. It could be a new product, a new process, or improvement of an existing product, improvement of an existing process. And the protection is for 20 years, non-renewable. For patents. But for utility model, it's lower kasi there is also a lower criteria compared to patent. The protection is only for 7 years, non-renewable. We have industrial design. Industrial design is any combination of 2-dimensional, 3-dimensional forms of an object. You know. It has also some certain criteria to fall under the protection of industrial design. And the protection of this is 5 years, renewable twice. So therefore, you have at least a maximum of 15 protection for intellectual property, for industrial design. Okay. We have some intellectual property that is still young in the Philippines. The geographic indication.
Mm-mm.
So geographic indication pertains to any products or services that are unique in a particular geographic indication around the world. No? So example, if I talk of Darjeeling tea, that means that tea is only found or will only be planted or will only grow in Darjeeling, a particular geographic place.
Mhm.
We also have topography of integrated circuit. Ito naman, the protection of this is 10 years and non-renewable.
Mm.
And the last is the so-called undisclosed information, or commonly known as trade secret. For a trade secret, of course, there's this protocol that any person or any company should have the protocol to keep it secret, because the protection will be only until the time it is kept secret. No? Yung
I
trade
see.
secret kasi, you keep it to yourself and you do not need to disclose it to the intellectual property office. Kailangan lang maiwasan mo na malaman ng iba yung sikreto mo.
I see. So, ma'am, what are those issues based from your experience nung nag-patent ka ng projects or research or invention?
Okay, so I have first an issue on ownership. Okay, no, normally we are in an academic setup
Okay.
wherein there would be the researcher, we call them inventors, and of course the facilities of the universities or the company that is being used by a researcher in order to pursue with a particular invention. So by the way, I worked as a freelance patent agent of the Intellectual Property Office of the University of the Philippines, Diliman. So one case there, Diliman kasi, the IPO of Diliman has a very good practice, no? Sa kanila ko kasi nakita yung ganong practice wherein there is a complete panel that evaluates each of the technology
I
that
see.
is applying for patent. So normally this panel is composed of who's the vice chancellor, who is assigned on the IPO, the legal officer of the University of the Philippines, a patent agent, a representative of the college, could be the department head or the dean of the person who is asking for patent application assistance, and a representative from the student who is in the field, no? Enrolled in the field of the patent being applied for. Okay? So it's a big panel. And then that's one issue of ownership. Example, if a masteral student or a faculty who is not deloaded, who is not given a fund to work on a particular technology, and then he uses the laboratory of the university during his free time. So the question now is, who owns the patent? Is it just the researcher only, or the university now co-own? Why co-own? Because by definition, if a researcher have utilized a substantial amount of resources in the development of the technology, then, now we're talking of the resources of the university, then, according to maybe on the IP policy of that university, the university now has a co-ownership on the patent. So dito we do deliberation, no? Kasi it's really so hard to measure the word substantial. So example, if the faculty is just using free time, then is it substantial? Yun yung mga sagot, no? So after stating those facts, etc., then the panel agreed after the deliberation that the technology is owned by the researcher.
Okay.
Kasi during free time lang pala siya gumagamit. So, hindi substantial yung amount in the use of the laboratory. Okay. Of course, marami naman kasi deciding among the panel. No? Another issue also is the issue when you finally found that what you are applying for is no longer patentable. Again, an issue of the that university. Kasi normally they are so active on funding agencies. Na example, there's a technology that is funded by the Department of Science and Technology. Okay?
Right.
But apparently, when we were applying for patent, we found out that there is already a prior art. The prior art means something that is already known or existing. If the technology you're applying for is already part of the prior art, then definitely you'll not be granted the patent due to the ground of lack of novelty. No?
Yeah.
So because of that, the panel deliberated and concluded that after a very extensive patent search, the patent search is a process that we do wherein we explore all existing patent databases and non-patent databases to check if there's already a prior art. Since we found out a prior art already, then we suggest not to push through with the patent application, because why push through with the patent application? We know that it will not be granted in the first place. Okay? But the problem is there's already funding from the OST. So this means our next step would now be doing again a patent search, this time to check the freedom to operate.
I see.
Because if you allow them, you know that there's already a prior art and you operate and you still push through with the technology, you have to check. Has there been any patent protection of that technology existing within the Philippines? Otherwise, you'll be infringing an existing patent. So there's this freedom to operate patent search technique wherein we have really to find out on what countries are those patents protected. Because we have the so-called PCT, no? PCT treaty wherein we have the filing on different countries. So, example, there's this patent technology in the US, then the inventor might want to protect the product to each territory that he wants to penetrate or to market the product, because the IP law is territorial.
Yeah.
Meaning, if you are protected in the Philippines, you're only protected in the Philippines. You want to be protected in the US and apply another separate patent protection in each area. So freedom to operate means that there is no patent protection by any foreign or local technology within the Philippines. Okay, so, well, luckily naman, we found out that they could have the freedom to operate because the technology is in Denmark, it's not protected in the Philippines, so they are free to do the technology only within the Philippines.
Alright.
Okay. Then another thing is about trade secret. So, just to talk about trade secret, trade secret is the opposite of patent. Kasi patent, you have to disclose to the government. You have to put it in writing, everything about the technology, how you come up with the technology, what's the process of making or creating the technology, and what are the applications of the technology. In other words, the government, IPO field, Intellectual Property of the Philippines, has the full copy or the full disclosure of your technology in written form. Eventually, this patent application will be uploaded in the Gazette, no? In the portal, meaning it will be readily available for all people around the world to read your disclosure. That's disclosure. That's for patent. Okay. But for trade secret, no need to disclose. You just have to have a protocol within the company. So I'm giving an example of my own company. So I have a startup company called Polite Technology Incorporated. I have invented innovative construction materials because I'm a civil engineer and a materials engineer at the same time. So my interest in research is on construction materials. My preference is trade secret.
Alright.
Because I don't, because in my opinion, the moment I disclose it, a lot of people can now invent similar to what I'm working. So I want to keep it as secret as possible. Okay? We have a trade secret within the company. We call it a backstab, no, backstabbing. We codified everything with the company. And then I have a problem when some of my staff were pirated by a supposed investor. Kasi I have an investor, supposed investor, and then when we were not able to come up, agreed on a MOA, so the investor decided to pirate my people.
Oh.
So, yun naman yung problema, no? So, ang protection ko naman doon, I had my people sign a non-disclosure and non-competition agreement from the time that I hired them. Ang kaso, ang problema nga, in reality kasi is, minsan, pirma lang yan na meron silang non-disclosure, no? Pero, there could also be some instances wherein these people might be able to share proprietary secrets to others. So, such as this. Now, I'm into going to legal procedures already. I've talked with some lawyers, etc. For me to sue them, I have to see an actual product that is copied from what I am doing.
Yeah.
Now, this happened to patents. Okay. By the way, also one exciting issue on copyright. Okay. So software, by the way, software is copyrightable.
Right.
It is considered the software is not patentable. But if you are developing a software and it's actually a system instead of a software, let me know. I'll be your consultant. We can actually tweak or do some we call this, we can do some adjustments so that we can actually work on patenting a system. We will not call it a software, a system, okay? But if you call it a software, then definitely it is just copyrightable, not patentable. So, apparently, if you own a copyright, you have two ways to earn. No? Microsoft, for instance, own copyright for their OS, the Windows. Okay? So, excuse. So, Microsoft will earn two ways. Number one, of course, selling or licensing of the OS, no, of the software. Second one is catching those who pirated or infringed, yung mga piracy. We know there are a lot of pirated softwares. So, Microsoft maintains a very strong legal department where the aim is just to police, especially BPO, no? We know Philippines is a big business process outsourcing company, call centers, etc. Wherein one call center could have 300 seats, 300 computers. So I have a friend who owns a call center who maintains 300 computers with pirated OS, Microsoft OS. So they were reported to NBI. There was a raid. Okay, tell you the damages. Okay, from that day of the raid, they paid $500,000.
Oh.
All PCs were confiscated, brought to NBI. They undergo court proceedings. Of course, at the last, no, it's still the court to decide. Okay, so after so many hearings, a settlement was crafted. No, the settlement was they have to pay a total of $60,000 as damages. Plus, they have to buy the licensed 300 licensed software for each of their computers for them to go back to operation, and a half-page apology in an existing or leading newspaper in the Philippines. Di ba ang bigat, no?
Sobra.
Ang bigat. That is the essence of the IP rights, no? Your rights, no? Na kumikita sila diyan sa panghuhuli pa lang nung mga tinatawag nating pirated materials.
So, ma'am, ano pong masasabi niyo rin sa RA 8293?
The Republic Act 8293, of course, that's the IP Code of the Philippines. It's a guide, no? It's a guide for us to know. Example, there are the part 2, 3, 4. Part 2 is about the patent law. Part 3 is about the trademark and the service mark law. Part 4 is about copyright law. So there, you could see, for instance, for patent, how to apply for patent, what would be the patent fees, what are the criteria to be patented. So this will be now your guide if you qualify for an intellectual property and what will be your rights.
Okay. Alright, ma'am. So, bukod dun sa polite na experience nyo, meron ba bang ibang very worst talaga na experience ninyo na isang invention na nagkaroon talaga ng problema na hindi na patent, hindi na...
I think what happened to my company, it just happened very recent. Now we're talking about this October 2018.
Oh,
So hindi ko pa
Last
nahuhuli
year.
mga culprit. Ano pa lang, ilang buwan pa lang, 3 months. So meaning I'm still waiting if there would be proofs of stealing concepts, design concepts, might fall under copyright, or stealing of my formulation, okay, which will be infringement of patents. Infringement. Kasi copyright is automatic, no? So, pwede ko na i-claim kung ginaya yung concepts ko, yung design concepts. Concepts kasi are shown in drawings, etc. And my staff were given those. For me, it is one of the worst I've experienced so far because of some financial impact on my company. Financial impact, nawalan ako ng investor, and then nawalan din ako ng tao. Of course, they were pirated, no? So, nalaki yung naging impact sa akin, sa moral pati ng mga tao within the company. So, now I'm, if you have an intellectual property, it's best if it reach the market. Ang concept kasi dito, why create an intellectual property and do not gain economically at all, no? Supposedly, when you are creating this intellectual property, ang talagang kikita ka dapat para magkaroon siya ng valuation.
Okay.
IP valuation na lang. May value siya kasi napupunta mo siya sa market eh. Tapos, although there's this really a reality that around only 5 to 7% of what were patented reach the market or are successful products. And also, by the way, hindi rin naman, it doesn't have naman na patented yung isang product para i-offer naman din natin sa market. It's your call. You just want to enjoy monopoly. Kasi tandaan nyo, if you own a patent or a right, you enjoy the monopoly. Ikaw lang yung pwede. The moment na may gumaya, pwede mo i-demanda. So, you earn twice nga di ba? From selling or from offering, and the other one, manghuhuli ka ng mga
Gumaya.
Okay. So far, kapag ang patent issue or an IP issues already affecting the financial position of the company or the person, worse na yun para sa akin.
Okay. I think, ma'am, that would be all kasi may meeting ka pa. Thank you, Ma'am Rian.
Thank you,